And I pointed out to you that my instructions were at that time that they were being mobbed outside court and assaulted and intimidated and effectively being prevented from entering the court. And when I raised that issue with your Lordship suggested that they should either approach the police or approach the court for an interdict. Now, my Lord, I wish to raise this issue again with your Lordship, and I wish to submit with respect that that is not the correct approach to follow, having thought about the matter. A different approach is needed in my respectful submission. And in this regard, I refer your Lordship to section 35 of the Constitution, and in particular subsection 3. C, which provides as follows: every accused person has a right to a fair trial, which includes the right to a public trial before an ordinary court. That means that the accused persons before your Lordship are entitled to a public trial before an ordinary court. And it is obviously your Lordship's duty to ensure that they receive a fair trial, which includes the duty to ensure that they enjoy a public trial before an ordinary court. Now, what that means, my Lord, is that their trial is to be conducted in an open court. That is the meaning of a public trial. An open court, in other words, a court open to the public. A court to which the public have free and unfettered access. So, your Lordship is obliged to ensure with respect that all and any members of the public have free and unfettered access to this courtroom where the trial is being conducted. And the corollary of that is, if certain persons are being prevented from entering the court building, the law, as has been happening, this trial cannot be a public trial before an ordinary court. That is the effect of what has been happening. Thus far, and to the extent that certain members of the public have not had free and unfettered access to this courtroom, the trial has been unfair. In that, the accused's constitutional rights to a trial before a public and open court has been infringed. This in turn means, my Lord, that your Lordship is obliged to ensure, and it's your Lordship's duty with respect, to ensure that members of the public have free and unfettered access to the court building and the courtroom. Your Lordship cannot abdicate its responsibility in this regard by simply saying these people should go and lay a complaint with the police or bring an application before this court for an interdict. And I'm not sure how that would work in any event, because if they don't have access to the court building, obviously they can't bring an application or file an application for an interdict with the registrar of the court. Until the situation is rectified, my Lord, in my respectful submission, the proceedings will be irregular, because this is not an open court. It is not a public court. And I just want to put everybody on notice, my Lord, and this is not a threat. that should the proceedings continue, and should this continue to happen, that I am going to apply for the entry of a special entry of an irregularity in terms of Section 317 of the Criminal Procedure Act. Your Lordship asked me on the previous occasion, but what should you do about it? It is correct that I didn't ask you for an order against anyone, but your Lordship is quite at liberty to, for example, summon the Commissioner of Police to court to ask him for an explanation as to what's happening and as to why certain persons are being excluded from the court building. And with regard, your Lordship could also ask him about the security arrangements. So it's not as though your Lordship's hands are tied. That by way of example. Your Lordship could also call or summon the head of this office or the head of security here at court to appear before your Lordship and to give evidence as to what's going on. So there are measures that your Lordship can take in this regard. But I object to the fact that my client's family and supporters are not being given free and unfettered access to this courtroom. Lord, I might mention to your Lordship that the way it works at the moment is that my clients are given 10 tickets in total to give to their family and supporters by the security officials here at court. And only persons who have those tickets are then allowed to enter the courtroom. In my submission, that is in itself unfair. I don't know who determines how many tickets each faction should get. In other cases, for example, the judge has ordered that the first 2 rows be given to the supporters of the accused and the rear 2 rows be given to the supporters of the complainants. That by way of example. But to only give them a total of 10 tickets with respect is wholly inadequate in my respectful submission. So that's all I want to place on record at this stage.
May I just ask a question?
Yes.
Are you moving this application for purposes of today or in future? Or for future purposes?
My submission is that for so long as the proceedings continue on this basis, where certain people have or do not have free and unfettered access to the courtroom, these proceedings are irregular. So I'll leave it up to your Lordship to decide when your Lordship should deal with the matter. Your Lordship could stand the matter down now and summon the Commissioner of Police, for example. I would have no objection to that. All we're seeking is a fair trial before a public court, before an open court. Thank you.
Thank you, Mr. Takalo. Mr. Ntelwa.
And the court is my lord. And my lord, my little friend is taken in this court in a difficult position. And the court on the previous occasions did ask to what would you want in the court to do. And he did not come up with any suggestions. The court went on to suggest that can we deal with this, that is between me and him. And if it does not come up with a solution, we approach the court. It is the first time I hear that there was anyone that was hindered to come to this court. And I believe, my lord, that we can sort this out without the involvement of the court and see who is doing that obstruction. That's my submission, my lord.
In the event, don't split out.
If that does not help, that's one That is where now we can approach this court in chambers and make some suggestions.
The
Then
problem I've been approached already, so the matter is before me now.
it is not clear as to who is doing that hindrance. That is the problem.
I don't know. What's your response to Mr. Doberman's submissions?
Unless I can get as to who is doing this hindrance, we can deal with this matter, I'm sure. And about the issue of the people, the 10 tickets, I think even that one can be arranged. We can sit down with the security and see as to what is the logic behind that. Understand that?
Thank you. Mr. Doberman?
I like doing things in open court so that we all know where we stand. But if my little friend can come to our assistance, I'll be quite happy with that. I don't know if he's got any control over the police, whether he can influence the security personnel, what he can do. I appreciate his offer. If he wants your lordship to adjourn to see what can be done, and then perhaps he can report back to you, I've got no problem with that.
Mr.
Can't we do that part? I mean, with this matter after the court's ruling, then I can come up with a solution with him. Let the process of the court proceed, then we can deal with this issue later.
But well, I just want to mention that I raised this issue before, and there was really no improvement. So that's why I'm forced to raise it now.
The problem I have dealing with it now is that most probably this is the end of my sitting in this matter. Probably, I don't know.
I understand that.
Yes.
But your lordship can defer the issue.
Which one? This one? The one you've addressed?
Yes.
Okay.
Thank you.
I think we will defer the issue. Let me deal with my judgment. The applications for leave to appeal by the applicant are premised on section 16, brackets 1, brackets A, brackets Roman figure 1 of the Superior Courts Act, number 10 of 2013. The section reads as follows, I quote, 16 appeals generally. 1. Subject to section 15.1, the Constitution and any other law. A. An appeal against any decision of division of as a court of first instance lies upon leave being granted, Roman figure 1, if the court constituted of a single judge, either to the Supreme Court of Appeal or to a full bench of that division, depending on the direction issued in terms of section 17.6, close quotes. Section 1 of the Act defines an appeal thus. 1. Definitions. In this Act, unless the context otherwise indicates, an appeal in Chapter 5 does not include an appeal in a matter regulated in terms of the Criminal Procedure Act, 1977, brackets, Act 51 of 1977, close brackets, or in terms of any other criminal procedure law, close quotes. Section 16.1A1, relied upon by the applicants, falls under Chapter 5 of the Act. The leave to appeal, therefore, thereof, is predicated on a wrong act and section and deserves to be struck off or dismissed on this ground alone. The background and the grounds upon which these applications are based need to be ventilated because of the clandestine manner in which the application was brought. When the trial started on the 8th of October 2018, Mr. Doberman brought an application objecting to the charges and sought an order to quash the charges. After argument, I issued the following order refusing the quashing of the charges. I quote, I most probably shall furnish reasons during the trial or at the end of the trial itself, close quotes. I further ordered the state to furnish the defense with further particulars required. The state obliged. Thereafter, the evidence of Ms. Cheryl Zondi was led and cross-examination started. While her cross-examination continued, an application for my recusal was brought on notice of motion. The founding affidavit stated succinctly the grounds relied upon. I shall not regurgitate these grounds as they were properly addressed in my reasons for refusing to recuse myself. Suffice to say that the new grounds based on facts not foreshadowed in the recusal application surfaced in the application for leave to appeal, which was argued immediately after I gave reasons. It has to be borne in mind that the applications for leave to appeal were served a day before the reasons were given. The application for leave itself is convoluted. It does not delineate questions of fact from those of the law. The words of my brother Chetty J, dealing with a leave application to appeal in the matter of Panayoti, resonate with this matter, where he stated, I quote, procedurally, the grounds upon which an application for leave to appeal are predicated are required to be clearly and succinctly tabulated in unambiguous terms to enable both the prosecuting authority and the court to determine its parameters. The first applicant's notice of motion for leave to appeal is unfortunately not a model of clarity and offends against the spirit and purport of Section 316 of the Criminal Procedure Act. It constitutes an amalgam of inane and vituperative comment and is moreover interspersed with a belligerent innuendo. Such deficiencies ordinarily warrant that the application be struck from the roll, but to do so would ultimately serve no useful purpose as merely delay the inevitable outcome of this application, close quotes. I was taken aback when I discovered that the application for leave to appeal encompassed, quote unquote, an appeal against the order refusing the quashing of charges. That was in spite of there being no application for leave to appeal that order. After the charges were put, the applicants refused to plead to the charges on the advice of Mr. Doberman. I entered a plea of not guilty on their behalf in terms of Section 109 of the Criminal Procedure Act. The trial proceeded thereafter. No reasons were sought, nor was there an application for leave noted in pursuit of an order. It is outstanding under such circumstances to learn for the first time in the application for leave to appeal that I refused to furnish reasons for my order. The order I made needs no elucidation. The trial is at its infancy stage, so to speak. As alluded to, new grounds emerged on the notice of application for leave and at argument stage. As a reminder or refresher, it is the duty of a legal representative to represent his or her client to the best of his or her ability. But foremost, it is the duty of that legal representative to strive at all costs to assist the court at arriving at a proper and just decision at all times, and not to endeavor or use strategies which shall set the court up for failure. Again, in an unprecedented manner, Mr. Price, in his oral argument, referred for the first time to an instance where Ms. Zondi was shown a copy of a ticket where the first applicant was in America. The background to this aspect can be gleaned from the record. The cross-examination went as follows, I quote, "All right, let's just go back. We are in Durban now. You have gone to Durban. You are in the house. You want to get away from this man, and he is raping you every other day, as I understand you. Is that correct?" "Yes, sir." "Virtually every day, is that correct?" "Majority of the week, he was doing this to me." Question, "From Monday to Sunday, the majority of the week, which means virtually every day. Is that correct?" The answer, every other day, yes. Every other day, yes. Not every single day. Not every single day, yes. And did this continue for the entire period while you were in Durban until you escaped? Yes, I am sad to say it did. I beg your pardon? Yes, I am sad to say that it did. every other day, every week, for the entire period while you were there? Yes, sir. Is that correct? Yes. You were staying at the house? Yes. So for that entire period, you were staying at the house. Is that your evidence? Yes, sir. Are you quite sure about that? Yes. He would only leave, he would only go to his wife's home to check on them. He would not stay there. He stayed with us. He was sleeping there. Yes, he was sleeping in the house with us. Yes. Yes, yes. And he slept there every night throughout that period until you escaped. Is that correct? Yes, sir. Is that your evidence? Yes, sir. Are you quite clear on that? Yes, sir. You can't be making a mistake? No. Are you sure? Very sure. All right. I want to show you a printout of a certain flight ticket. Flight tickets. Have a look at this. Have a look at it, please. Is this, that was a question. The answer, is this his trip to America? I've underlined this portion. Yes. That you are going to talk about? Yes. I had forgotten about it. My mistake. Well, that is very unfortunate. Answer, it happens. Just have a look at the ticket. You will see it is from Flight Center. Shall we mark it with the next number, Your Lordship? A few questions, close quotes. A few questions down the line, I made the following remark. Court, I just want to make an observation here, Mr. Doberman. Mr. Doberman, yes. Court, that the witness mentioned that trip to America even before she saw the ticket. Are we all in agreement in respect of that? Mr. Doberman, well, she mentioned the trip to America. Court, when you were just handing in or showing her the ticket, but before she could see it. Mr. Doberman, yes, yes, I'm in agreement. The court, okay. Mr. Doberman, before she saw it, she mentioned it. Court, okay, okay, thanks. No, that is what I wanted. Thank you. Had I not raised, close quotes rather, had I not raised this, the record as it stands and as seen from the underlined portion would not have shown that the answer was given even before Ms. Zondi saw the ticket. At the stage when I said this, I had an idea in my mind of the style and line of questioning the defense was pursuing. Hence, I wanted that to be reflected on the record. It is astonishing to hear Mr. Price raising that for the first time in argument, that the applicants perceived it to be biased in favor of the state. It is disconcerting to hear the assertion for the first time in the application for leave to appeal that I allegedly had a cozy relationship with the complainant because I repeatedly made the following comments, I quote, that she wished to rest, sit down, take a break, and asking her from time to time if she was still fine. The Honorable Court was unduly close to the complainant and was attempting to mollycoddle her, close quotes. This submission is disingenuous. It is deliberately taken out of context. The anguish Ms. Zondi was in at the time she testified is abundantly clear. She was continually getting emotional, shedding tears, and breaking down at times. Because the matter is broadcast live on various television networks and social media platforms, her condition in the witness box is public knowledge. It was during those moments that I used the impugned expressions. Those moments are not reflected in the record. I shall not conduct this trial by prefacing such statements by saying, for example, I quote, I can see you are crying or emotional. Are you still okay? Don't you need a break? Do you wish us to adjourn to allow you to compose yourself? Close quotes. As I was steeped in the trial, I was able to pick up and formulate the strategy the defense was pursuing. I made it a point that those silent parts of the evidence be thoroughly explained so that the record reflects them. That is why I asked Mr. Doberman, as I did about the ticket to America. Had I not been wise to do so, a submission similar to the one dealt with in paragraphs 8 and 9 above would have been made. As aforementioned, presiding officers rely heavily in their function on the assistance of the legal practitioners, who are first and foremost officers of the court. Adjudication of cases is not a game. It is not about who wins and who loses. It's about doing justice. The primary and ultimate duty of each officer of the court is to see to it that justice is not only seen to be done, but it is done. The test whether leave to appeal should be granted or not is the reasonable prospect of success. It is tried without the need to cite any authority that leave to appeal may only be given where the judge or judges concerned are of the opinion that the appeal would have a reasonable prospect of success, or there is some other compelling reason why the appeal should be heard, including conflicting judgments on the merits under consideration. I exhaustively dealt with the grounds set out in the notice of motion by the applicants, and I need not regurgitate them. I stand by them in deciding these applications. I've also dealt with those grounds which were either raised in application for leave to appeal or in argument. I have addressed them and need not repeat them. Applying the test, I am of the view that there are no reasonable prospects of success, nor are there any compelling reasons why I should grant it. Consequently, I make the following order. The applications for leave to appeal are dismissed. Mr. Doberman?
Lord, if I may address you on the further conduct of this matter.
Yes.
My instructions are that the accused seek a postponement of this matter in order to petition the Supreme Court of Appeal in Bloemfontein for leave to appeal against the judgments mentioned in your Lordship's judgment. And in my submission, in all the circumstances of this case, your Lordship should grant them an opportunity to pursue their appeal rights. Thank you.
Without having him, I think I'm of the same view.
As your Lordship.
Yes. To which date can we postpone this?
Well, I anticipate that we won't have a decision within a month. So
No, sure.
the beginning of December to a provisional date.
I thought beginning of December, is it fine?
Yeah, I understand that it is a 30-day process, so I think December will be fine. That is the.
Which is, what about the last week of term, Mr. Doberman? That is the 14th of December.
Last time is the 14th, yes. That week.
I think the 14th of December.
Yes, madam.
A Monday would do, or a Tuesday?
On Friday, I think that
Monday the 10th, we look at the
10th of December.
10th of December.
Mr. Doberman?
Check my diary.
No, it's fine.
10th of December will be fine. Thank you.
Mr. Waban is around? Yes. For the benefit of the public as well. This matter has come to an end so far.
In the
interest of justice, we have to allow the accused to pursue whatever goal they want to pursue. Like in this instance, they seek my recusal as well as an appeal in respect of the quashing of charges.
bukhawulelane neemfuno zawo bavunyelwe abamangalelwa balandele ke loo ndlela abafuna ukuyilandela. Umzekelo apha kweli tyala baqwenela okokuba ndirhoxe ekulichopheleni ityala kananjalo nokokubana kuphuthiswe isimangalo ezijoliswe ngakubo.
And in addition to that, they seek that the matter be postponed pending the resolution of applications.
Phantsi kwalo meko bacela ke ngoku okokuba eli tyala limiswe kusajonge okokubana iziphumo zezo zicelo zabo okokubana ziya kuthini.
It is in the interest of justice that I should allow the matter to be postponed and not proceed with it whilst these two applications are still pending.
Kusemdleni wobulungisa okuba ityala limise kungaqhubekeki ngalo lo gama kusaxhomekeke okubana kulindwe iziphumo zezi zicelo zimbini.
For that reason, therefore, the matter is stand up accused.
Ningaphakame ke stand up.
For that reason, the matter is postponed to the 10th of December 2018 provisionally.
Ngenxa yoko tyala limiselwa mhla weshumi kaDisemba okwethutyana nje 2018.
Hopefully things would be clear by then.
Siyathemba into kokuba izinto zobe sezicacile ngoko.
So accused number 1, you shall remain in custody as before.
Mangali lokuqala uyakuhlala usevalelweni njengokuba bekunjalo ngaphambili.
Accused number 2 and 3, you shall be out on bail on the same conditions, and I think we relaxed the condition that you should report to the police on whichever days you were supposed to report.
Umangali losibini nawesithathu ngaphandle ngebail ngokwalami iqathanga ibinjalo ngaphambili ndicinga into kokuba siye salikhulula loxanduva lwenu lokuba funeke niyokusayina noba kweziphi intsuku police station.
That is all, Court shall adjourn.
Judge Mandela Makaula, they're dismissing an application for his recusal there from the Timothy Omotoso rape trial. It seems that proceedings have now been postponed to at least the 10th of December. Just whether it will indeed be that date will depend on the Supreme Court of Appeal, which of course the advocate Doberman has now said he will approach regarding the decision taken there by Judge Mandela Makaula to not recuse himself and indeed reject that application set forth towards him there. So we will continue to unpack that case.